Hi everyone, my name is Sfiso Benard Nxumalo, the president of the Oxford Law Black Alumni Network. Welcome to our Changemakers series. Today I am privileged to be joined by Justice Steven Majiedt, who is a constitutional court justice in South Africa, and he has made a very long journey to join us today. And I won't waste anyone's time and just jump right into the interview. Hi, Judge. Firstly, thank
Morning,
you
Sfiso.
for joining us today. Perhaps just for those who don't know, could you just maybe give us some reflections about who you are, how you started this law journey, and what you're currently doing?
Right, just to say it's a privilege to be here and to speak to law students. I was a young man who wanted to become a doctor, and my then school headmaster persuaded me that that's not a good choice because of mathematics and also couldn't stand blood. And I became a lawyer. And he did at the time say, I grew up in an area in the Northern Cape, which is a central province in South Africa. And I finished my schooling in a city called Kimberley, which is well known for its diamonds all over the world. And he at the time said to me that South Africa is going to need young lawyers because change is coming to the country, that democracy is going to come, and that it will be accompanied by a great deal of strife, civil strife, and a great deal of cases, and young lawyers would be needed. And that persuaded me to become a lawyer. So I finished my law degree at the University of the Western Cape in Cape Town, where I am now just been appointed as an honorary law professor. And I then became what is known in South Africa as an advocate, which would be the equivalent of a barrister in the UK. And I practiced there for about 15 years. In between, I took a short break to join the civil service as a chief state law advisor in my old province, the Northern Cape, at the request of the government there for 2 or 3 years. I went back to practice and I became a judge of the High Court in Kimberley at the age of 39 in the year 2000. I stayed at that court for 10 years. In the year 2010, I was elevated to our appeal court known as the Supreme Court of Appeal, which is a misnomer. It's not the Supreme Court, it's the Court of Appeal. And in 2019, I was appointed to our highest court, the Constitutional Court. That is where I am at the moment.
Thank you so much for that. So, just perhaps to understand what kind of work you were doing as an advocate during apartheid, what kind of work were you looking at?
Well, I joined the bar in 1984, and that was just about the time when civil strife erupted in South Africa. The government imposed 2 states of emergency under the emergency laws, and there were many cases of political activists and combatants of the liberation movements, APLA, of the Pan-Africanist Congress, and of MK Mkhonto we Sizwe of the ANC, who were prosecuted for in political trials for civil disobedience and acts of violence against the government. And so I did a great many of those cases. I was privileged to be at the bar in Cape Town on the 5th floor in chambers called Huguenot Chambers, one of the relics of apartheid, that name Huguenot Chambers, with the first post-democracy Minister of Justice, Dalla Omar, who was appointed by President Nelson Mandela as our Minister of Justice. And he is one of the lawyers who mentored me and guided me, because as I say, I was on the same floor as him, and my chambers was about 5 doors away from his. And so we did a great many of those political cases all over the country for the first 5 or 6 years until liberation came in 1994. Well, first with the unbanning of the ANC and other liberation organizations in 1990. The cases tapered off, but remember the cases continued because they were ongoing. And so up until 1994, a great deal of my work was defending activists and combatants, but also doing civil suits against the government, against the police and against the defense force for delicts committed against our people, either through physical injuries or other delict.
So, I find this curious. Would you say that at the time when you were advocating and assisting people with or providing public defense for those who have been accused, would you say that the law worked in their favor most of the time? Would you see courts as being fair and biased, or were they part of the machinery? Because I think sometimes, it's easy for us to think that, well, because it was an apartheid system and the courts operated within that particular system, that they were bound to make decisions that favored government. But as a lawyer, did you have any hope when you were doing these sort of cases, and did they work out favorably?
Yeah. Now, I must remember that magistrates in the lower courts and judges in the higher courts were appointed by the apartheid regime. In fact, the Minister of Justice had carte blanche in appointing these judicial officers. So by and large, they were part of the apartheid machinery. They were the odd exception here and there, but by and large, we faced an apartheid machinery even in the courts. And we were under no illusions. We did the best we could, but 8 to 9 times out of 10, we were up against it. And even the prosecutorial services were geared towards almost ensuring that the justice was not done whenever there were political cases before the courts and whenever there were black people tried and charged with political offenses. So it was a battle against the apartheid machinery, even in the courts. And we were under no illusion, as I said. And that went, unfortunately, even to the highest court at the time, which was the appellate division. Even there, the judges, 9 times out of 10, were there to make sure that the state succeeded in its goal, which was to divide and rule and to oppress in terms of apartheid's whole ideology.
And do you have any notable cases, maybe, or impressionable cases that either changed your belief in the legal system or reinforced your belief, or had some form of an impact on you?
Well, there were many negative cases. There were cases where one of the state's favorite modus operandi was to extract confessions at all costs, especially in high-profile political cases where people were charged with terrorism or sedition or acts to undermine the state. And so at all costs, especially those police in the security branch were told, and actually physically did so, extract confessions from suspects. And so there were a lot of people beaten into confessions. And so many of those confessions almost invariably were challenged as being not freely and voluntarily made, as the Criminal Procedure Act states in Section 217. And those led to many trials within a trial, where you first determine the admissibility of the confession before you get to the merits. And in many instances, we had clear evidence of those confessions being beaten out of suspects. But to no avail. Judges found a way of getting past it. But there's one particular case that stands out for me. There was a man charged with committing an offense in a part of our country known as the Eastern Cape, in the largest city then, Grahamstown, whose name is now, Port Elizabeth, whose name has now been changed to Kabeja. And the judge was an acting judge, Sutej. I will never forget him, he was a Polish immigrant. And he fled to South Africa with his family because of the persecution of the Poles at the time of World War II and thereafter. And he was fiercely opposed to the apartheid regime. And as I say, he was an acting judge. And because they were flooded with cases, they sent him there from Johannesburg, our largest commercial city, to go and help out with all the cases in the Eastern Cape, because the Eastern Cape was a hotbed of political activism. He sat in this case, and one of the people charged there with sedition and with murder and with other offenses against the state was actually in custody in another case, and we had the records to show it. But the prosecutor refused to divulge the contents of that evidence. And the prosecutor is duty-bound and obliged to provide all evidence, even those evidence that favor an accused, to the court. And some or other way, we were able to place that evidence before the judge. The judge was absolutely livid. And it's the first time that I saw in a court during that apartheid times where a judge actually berated not only the prosecutor, but he berated the state. Because this man potentially faced, at that time the death penalty was still constitutional. I was prior to our present constitution. That man potentially faced the death penalty. And he was livid, and I'll never forget what he said in court. He said to the prosecutor that you are the epitome and you are representative of what this apartheid state stands for. And it actually carried a lot of newspapers, and needless to say, he was never asked to act as a judge after that again. But justice was done there simply because we were able to get that evidence on record, despite the prosecutor refusing to disclose, and as he was ethically obliged to do, disclosing that evidence to the court. That case stands out for me. There's been many cases after democracy which has the opposite effect, but speaking of apartheid times, it was one of the rare exceptions where justice was done, despite against all the odds.
Now, I just want to change gears a little bit. I read, and you've shared the story with me before, about your opportunity to go study overseas, to further your studies overseas, but you turned that down.
Yes.
Could you please just retell that story?
Yes, I finished my second law degree, my postgraduate law degree in 1983. I was then 22 years old. When I was 23, I went to the bar to become an advocate, a barrister, because I couldn't find articles to do anywhere in my old hometown in Kimberley to become what is known as an attorney back there, a solicitor in the UK law. It was simply because I wasn't the right color, I was black. And then I took the plunge and did a thing that you not normally should do, is to go straight to the bar. Normally you would become an attorney first and then go to the bar. Because that, as we know, in the UK is the same, it's a referral profession. And as I say, I was on the 5th floor at Dullah Omar, and it was the time of the first state of emergency, 1985. I was 24 years old, I was unmarried. I had no commitments other than to practice at the bar. I had no immovable property and so on. So I was free to go. And I got a prestigious Fulbright scholarship to go to Stanford University, which, as you know, is one of the Ivy League universities in the United States. And I got ready to go, and Dullah Omar came to my chambers one day and he said, "I understand you're going away." I said, "Yes." He said, "Well, you can't go." I said, "Why not?" I said, "I've got no commitments here, I've got no obligations." He says, "You've got an obligation to the country." And he persuaded me to say that, like my old headmaster, and that reminded me, my old headmaster said to me, "We're going to need young lawyers." And he said the same to me. He says, "The state of emergency is here. We are challenging these regulations. We're going to have young lawyers travel all over the country to defend our people and to fight the state of emergency." And he persuaded me to stay. And so I missed out on that opportunity. And a few years later, I got another Fulbright to go to Northwestern University in Chicago. But I couldn't go because then I was happily married. I had a young child and I was settled. I had a bond to pay. I had tax to pay and so on. But I must say, despite missing out on that opportunity, I've never regretted it. What I have regretted is not studying afterwards, perhaps part-time when I became a judge, when time permitted to do a master's and perhaps a doctorate in law. But it was so much more satisfying for me to help, in my own small way, to help build the country towards a new democracy, because I got involved in many high-profile cases. And it shaped not only my life as a lawyer, but also my life as a person, because through those cases I learned so much about our political situation, our political history. And as I say, it stood me in good stead, and I do not regret for 1 minute the fact that I lost out on those two opportunities, especially the Stanford one. And Sfiso, I think I should just relate a story from the days that I was in practice on the 5th floor at Huguenot Chambers. Now remember, this was in 1985. The country was in the state of emergency. The country was literally burning right through because there was an uprising. The African National Congress was banned, and so were many other liberation movements. But internally there was an organization, a grouping of activist bodies formed called the United Democratic Front. And although we didn't say it outwardly at the time because it was against the law, it was really a front. It was the internal wing of the ANC, and that was fomenting all the uprising and coordinating it, and there was a genuine feeling all across the country that the time has come for South Africa to be freed from the shackles of oppression under apartheid. And so remember, the ANC, as I said, was banned, and the 5th floor, mostly black lawyers, including Dullah Omar, very prominent political lawyer, they refer to us as the ANC floor. The building had about 17 floors in fact, all advocates. And one day in 1986, there was a bomb scare. Somebody phoned in to say there was a bomb in the building. Now, this is a state of emergency. Things are very tense. The country is burning. And so people took this seriously. And somebody on the 16th or 17th floor, one of the white advocates said, well, what we do is we should just check if the chaps on the 5th floor are there. If they are there, then it's a hoax. And that was typical of the time. But we had hard times, but we also, as I said, we were able to form a cohesive unit as we joined the fight against apartheid as lawyers.
Thank you for sharing that and relaying that, because it makes me appreciate the fact that I had the opportunity, of course, to come study here without ever thinking about whether or not I would have to, serve my country and think about these long-term issues. I could very much be quite selfish in my reasoning, and that's obviously a consequence of the constitution coming into effect and really South Africa becoming a constitutional democracy. But I'm curious, you've mentioned quite a few key people in your life, and I'm assuming that you value the idea of mentorship and that it's played a role for you. I'm curious as to what you think the role of mentorship is, particularly for marginalized groups such as women, black people, and so forth. What do you think the role of mentorship is?
I think mentorship is crucial in any profession, but particularly so in law, because remember, as a lawyer, you are representing your community. And more often than not, lawyers from disadvantaged backgrounds like women and black lawyers would act for people from those communities. And so I think it's important that you do the best you can and that you get guidance from somebody who's been in the profession a long time. I have been privileged to have had mentors from some of the leading black lawyers in South Africa, like Tala Omar, Tembile Squehia, who became one of the first judges of the Constitutional Court. I was his junior as an advocate for in many, many cases. And Pius Langa, who became our first African Chief Justice. And they mentored me. It's important to receive guidance because as a referral professional, especially as advocates, you are in the midst of litigation as a forensic lawyer, because we do court cases, unlike attorneys who sit and draft contracts in their offices. We're in the midst of the battlefield. And so it's particularly important that you receive guidance from those who have gone before you. Mentorship is absolutely crucial. When you're a woman in the profession, even now, whether you're white or black, you are up against it because men do not trust women to be able to do the work that they think men can. And it's the same with black lawyers, especially with commercial work. And that is why you almost got to be better than your peers who are not women and who are not black. And so you got to put in that extra effort. And that is what mentorship will help you achieve to do, because those who would mentor you have come that route before. They know all the pitfalls. They know the path to success, and they know how to overcome prejudice and how to overcome obstacles on the way to the top. Because it's not an easy road, but others have traveled that before, and why should you not learn from them as much as you can? And so I'm a huge proponent of mentorship.
And do you think that the legal profession, particularly in South Africa, has transformed over the years? Has it made sufficient progress? Or when you sit at the Constitutional Court, you still see perhaps the same faces when it comes to commercial matters, and even the black advocates that appear before the Constitutional Court might be the same advocates repeatedly coming in, having different representatives? So is that necessarily transformation if you just have person X representing 16 different parties and
Yes.
the same matters? Well, but yeah, so I'd just like to get your view on that. Do you think there's sufficient
Well, I think we
progress?
still got a long way to go. There's been some change, but there's been very little. And change does take time to happen, but I don't think it's happening fast enough. As you say, whenever a black counsel appear in high-profile matters, it will be the same faces. And that's very regrettable, because we have very, very competent, not only black lawyers, but also women lawyers in South Africa of all colors. And so one of the great ironies of our profession, and I can maybe relate my own history. When I was a young advocate, remember, I never practiced as an attorney. I came straight from university because there were no opportunities. And so you get the run-of-the-mill cases of small criminal cases before we started doing the big political cases. You would get unopposed applications, really things where it's like mundane run-of-the-mill stuff. And then when there's a fairly big civil matter coming up and they say, well, shouldn't we give him a chance and brief him in this matter? They would say, well, he's got no experience. Well, that's a chicken and egg situation. How are you going to gain experience if they don't give you the cases?
Right.
And unfortunately, one of the great ironies of our profession at the moment is that people say you can't give work of high-profile commercial, like tax cases and patent law cases and even shipping cases, to black lawyers because they have no experience. Well, here's the answer. We just never got those cases to do because they were all sent to white advocates and to male advocates. And so you don't gain any experience in it. So, as I say, it's a chicken and egg. How are you going to get that experience if you were never briefed in it? And it's the same with judges. You get appointed as a judge and they say, well, that judge doesn't understand shipping law, doesn't understand tax law, doesn't understand intellectual property law. But that judge has never been exposed as a lawyer to that kind of work. So are you going to just pluck the experience from the air? And so it's a self-defeating sort of argument where people get they just don't get the opportunity that they deserve, and they get shielded from work that not only is experience but also lucrative work in the profession, and ultimately they get blamed for not getting that experience.
And do you think that there's any role that the judiciary could play in advocating for more transformation? So, is it maybe should you make it a requirement that every time someone appears before court they must have a black woman, or does this just lead to tokenism, as people might call it, that you just have juniors as tokens?
Yeah, no, I think the judiciary's hands are tied in that regard, which is regrettable. I think we need to keep our distance from the profession. But there are those who can make a difference. I mean, if for example, government just practice what they preach. Government talks about affirmative action and about giving opportunities to black lawyers and so on. But ultimately, when the really high-profile government cases come before court, they brief the same white lawyers that you see in other cases too. And so they don't practice what they preach, and that is a great regret because, as I say, we have many, many able women and black lawyers in South Africa who can do those cases.
So, just also to change gear again, 1994 comes, 1995 comes, 1996 comes. Now South Africa is fully transitioning into a constitutional democracy. There's now the final constitution that comes into play. As a lawyer and as someone who later becomes a judge, what are some of the tangible benefits that you saw from this? What were some of the things that started changing for you as you were practicing law?
Well, I think the one thing that we as civil rights lawyers brought to the table when we became judges is a great deal of empathy for the vulnerable and the downtrodden, and we need not be told about what the reality is of poor, vulnerable people who are suffering the ignominy of apartheid. We lived it ourselves. And so there's a great deal of empathy brought to the bench by those of us who practiced law. We also understood what it was like to be denied opportunities, and I think it brought a whole new paradigm and thinking to the bench. And that is why I think a constitution, when you transform the bench in a new constitutional democracy, you're not just putting token black people there. It must also be a transformation of the mind, of the paradigm, of the thinking. And I think that is key to having a properly transformed judiciary in South Africa, is to have transformed minds, not just to have token blacks sitting there, because, I mean, history has shown us that some of the black judges, well, it's the exception, but some of them have become the most conservative judges, despite their upbringing and their background, and who are reluctant to change, and who still continue to refuse to move that paradigm shift, where the constitution has to be a living document, where people must actually feel its effects in the judgments that, especially in the highest court, in the constitutional court, the judgments come from that court.
So there's, over the past couple of years, perhaps even more recently, there's been prominent individuals who have said the lack of progress in South Africa is due to the courts and the constitution. They have pointed at courts and saying the constitutional court particularly has been an impediment to the Section 25 clause having full effect because you don't, I suppose, implement it properly. And of course, I use the word implement here quite loosely. What would be your response to that, or some of your thoughts about that?
Yeah. No, that is true, and I've just spoke at a law conference, international law conference last week at the University of Dublin, and the same question came up there. When we were lawyers, and even as judges in the High Court, as a trial judge, we used to say that when parties settle a matter, a good settlement is when neither party is completely satisfied. That's a good settlement. And so I think we're in the right space because as a judiciary, those blaming the judiciary for the impediment in progress are criticizing us from both sides. Last week, we related the story of how there's a growing trend towards constitutional abolitionists who say that the constitution should be abolished altogether because it's not progressive enough and change is not coming. And then there's the other group, that's the group mostly from the ruling party, who say that the courts, and particularly the Constitutional Court, is a break to progress because the court reins in the abuse of power. And I think that one is a nefarious group who would like to have carte blanche to do as they please. And we have seen in the last 5, 6 to 10 years what has happened in the country when the courts have not reined in those who want to abuse power. And so I think we're in a happy space. Nobody's happy with us. And that means we're doing our jobs right. And people must always remember that the Constitution is not a magic wand. It was never meant to be able to be a document where you wave that magic wand and all South Africa's centuries of colonialism, of colonialist oppression and of apartheid oppression would simply disappear like mist before the rising sun. It doesn't work like that. It's a work in progress, and the Constitution is only as good as those who have to implement it. Judges don't implement the Constitution. The executive and the legislature must do their work. And unfortunately, those two arms of government have been failing in the last 9 to 10 years. And the courts are the only ones, and I say that subjectively, but also the objective facts will show that the courts are the ones that stood up to uphold democracy, to defend the rule of law, and to ensure that South Africa succeeds.
Those are very scary and sobering reflections, and I might have to discuss this a little bit more with you. But would you say that due to the failings of these two arms of government, it's then necessarily brought the court into a political space where the court now is sometimes called in to adjudicate matters that perhaps in 1995 would have been left out of the court for being political and not really legal questions. But now you find that more and more political parties are finding themselves at the court, and more parties are bringing people or bringing political questions to be addressed by the court. Do you think that's a necessary consequence of the failings of the two arms of government? And if so, is that something that we can reconcile ourselves with the role of the Constitutional Court, specifically being somewhat of a political actor or a court that's involved in settling political disputes?
Well, a now retired colleague of mine who was in the High Court and was also the head of the Competition Appeal Court, Justice Dennis Davis, co-wrote a book, and he and his co-author coined a phrase called lawfare. Yes. It's a play of the word warfare, and that depicts exactly what's happening in South African courts. Because politicians have these fights, they trust the courts more than they trust their own dispute resolution mechanisms. They tend to bring these cases to court all the time. And so unfortunately the courts, especially the apex court, the Constitutional Court, have been thrust into this role where they have to deal with cases that they shouldn't deal with, political disputes and so on. And it's becoming more and more and more the case. But the court has got to be very careful. One must be careful not to become an activist court. You must stay in your lane. You must respect the separation of powers to understand that you can't legislate as a court and you can't make policy. Legislation is for the legislature and the making of policies for the executive. And so much as the temptation may be to sort things out at the court, for example, the court has got very wide remedial powers in Section 172 of the Constitution. One has to be careful not to invoke that power to legislate or to try to make policy which is really meant for the other arms of government. The temptation is there, but you got to stay in your lane. Having said that, the court mustn't hesitate to step in where it needs to step in, and the court has done so decisively where things have just gone wrong. And it's a very careful balance that you have to strike. But I think the court so far has managed to do that.
So I have my own views about some of these decisions and the correctness of them, particularly the Nkandla decision. I think that's when things took a turn for the worse. But that's for various reasons which we won't discuss. I just want to know, what are some of the cases, perhaps in recent times, that you've been involved in that hold a very close place in your heart, that are quite dear to you? Maybe Tubakale, for instance, which is a recent decision.
That's the one case I would mention. Tubakale is the case where the housing crisis, people who had been sent from pillar to post by government for over 20 years, who've been allocated housing subsidies in terms of the existing legislation, the Housing Act and the Housing Code, both of which were promulgated under the overarching requirement in the Constitution that government must progressively realize the right to access to housing. And so for over 20 years, they were sent from pillar to post despite having been granted subsidies, by being allocated land, and they didn't get the houses that they deserved. Very, very poor people. And so they went to the High Court, and the High Court made an order. They went to the Appeal Court, the Appeal Court made an order. They went back to the High Court, and the High Court made an order but refused them constitutional damages, and they came before us. And the court was split, and I wrote a judgment which said that they're entitled to constitutional damages as a matter of last resort, that no other remedy would give them effective relief as Section 38 of the Constitution requires of the courts to do. But I was in the minority. The majority said no, they have to go back to the High Court for contempt of court proceedings. It's a matter that is very close to my heart because that reflects South Africa today. It's a society where it's the most unequal society in the world, where the rich are extremely rich and the poor are extremely poor. And those are the poorest of the poor who have been denied basic right to access to housing by the authorities. And I thought that this was a case where constitutional damages, which is rarely awarded, is the only effective remedy to give them the relief that they require. And as I say, it was in the minority. And that case is very close to my heart.
Yeah, and I mean, that case is quite unfortunate because the majority takes a very regressive turn, if I may say. You know, yes. It takes us back to having a dichotomy between civil political rights Correct. And socio-economic rights, which is, in my view, untenable and unnecessary, really. But beyond that, what do you think the relationship should be between academics, practitioners, and the judiciary? Should you have a disconnect, which sometimes seems to be what's happening, where, for instance, in commercial matters, academics are saying, oh no, the Constitutional Court is wrong, and here's what should actually happen, and you should actually not go to court anymore because you're just going to mess up our pristine common law and our pristine sort of Companies Act and so forth. And then you have practitioners who sometimes don't actually engage with academic literature, but rather just focus solely on what is the black letter law and then advancing the interests of their particular clients. So I was wondering, what do you think a optimal relationship would sort of be between those three actors?
One must always understand that all three play a role, but judges, the judiciary, is a reactive role player. We can only act on the cases that's before us. And so the lawyers bring the cases, and the academics who write the articles can provoke some kind of intellectual discussion on topics. But ultimately, the judges, it's out of their control. They can only deal with the cases that come before them. And so there is this worrying trend that people say that commercially the courts are not up to standard. And many of the commercial cases are going into private arbitration, which is very unfortunate. I think the criticism may be valid in some instances, but the criticism is also overrated. I think there's a lot of... South Africa is a very strange society in the sense that those who have, especially corporates, are reluctant to let go, despite the legislation that say they must let go, affirmative action and black economic empowerment and so on. And so in a sense, they keep matters away from the court, and it's the old argument. If people are appointed who didn't get the experience, how do you expect them to deal with these cases in the same basis as those who have dealt with these cases for generations? It's something that won't go away in our lifetime. It probably won't go away in your lifetime. Probably your children would see a different South Africa where there's really equal opportunity in all kind of cases.
In closing, what would you say to any aspiring lawyers who want to take on either law students or junior lawyers who are starting this journey? What would your words of wisdom be if you could provide sort of generic mentorship?
Yeah, I must say, if I had my life over, I'd become a lawyer again. It's a fascinating profession, and as a lawyer and also as a judge, I've done cases over the whole spectrum. I was fortunate to be exposed to fundamental change in our country. I was a lawyer at the time when South Africa changed completely, and I played my role there, and I'm trying to play my role in the new South Africa. For any young person who want to become a lawyer, I would strongly advise that person to think about law as basically life. Law is life in the sense that there is no aspect of life that's left untouched by law. From the cradle to the grave, the law dictates your everyday existence. And so law plays a central part in our lives from beginning to end. And as a lawyer, if that's what you want to do, is the right profession to go into. But then you must become a lawyer also for the right reasons. If you want to become a commercial lawyer, you must understand you want to make money, and you want to do that kind of work. If you want to become a human rights lawyer, it's a different kettle of fish altogether. We as human rights lawyers used to always complain about Advocate Omar, Tala Omar. The rule at the bar is that the junior gets 2/3 of what the senior marks. Now, we always used to complain that 2/3 of a very small fee is even smaller. And so Dala Omar was known as an activist, a political activist, who almost charged his clients, although there were fees available because we got funding from overseas, he would charge the bare minimum. And so it wasn't rewarding financially to be his junior in a case. But you got immense reward from seeing people getting helped who wouldn't have had help otherwise. And so become a lawyer for the right reasons, but it's the most rewarding profession for me. Well, it's the only profession I know. But as a person, it's the most rewarding profession that I can think of. One could probably argue that becoming a teacher or becoming a nurse could be equally rewarding. But then it depends on what perspective you have on life.
Yeah. Okay. Thank you so much for joining us.
Thanks, guys.